this evening, but we would also like to reserve this time for our speakers at the beginning before we start throwing the questions at them. For everyone who's just joined, we're just giving it a couple of minutes to let the late people jump on. We won't wait too long. I know you've got valuable time here, as do we all. Just give it 3 or 4 minutes. Jack, I like your Zoom profile picture. That's not my monkey. I enjoy that. I see a lot of familiar faces signing on. Thank you all for being here. Jackie, you like my shirt? Thanks, Sue. Thanks for picking up on that. I didn't know if I looked too casual in the t-shirt this evening, but it is relevant. It's the "When There Are Nine" quote from Ruth Bader Ginsburg. I think we might have time to talk about that if anyone wants to. I believe Professor Virelli might know a little bit about that topic, Alyssa as well. All right, guys, I'm just going to give it 30 more seconds here, and then I'm going to go right into my little intro, and I'll try not to talk too long because I know you're not here for me this evening, and I would be sad if you were only here for me this evening because we have people who know this stuff. I'd like to think much better than I do, although my work in the last couple of years has me learning things that I never thought I needed to possess knowledge of. And I'm becoming an expert in a sense that I never expected to be. So, all right, we're up to 64. This is a pretty good start here. So I'm going to jump right into it. This event is being recorded, everyone. And so just to keep it, clean, and for people who are coming in later and watching this at a later date, please keep your microphone muted until we get to the live Q&A portion, and then we'll ask you to raise hands and we'll try to call on you as we can. I'll also be watching the chat during the discussion, so if you have questions as our speakers are talking, I'll be monitoring those, and we'll try to get to as many of those as we can this evening within a reasonable amount of time. I think we could probably be here for days or weeks if we address this entire topic in full. So for those who don't know me, I am Lindsay Palega. I am this year's incoming co-chair of the League of Women Voters St. Petersburg Area Reproductive Rights Committee. It's a little bit of a mouthful. I am very excited to be taking this position from Amy Weintraub and letting her go focus on her efforts into very similar work in other spaces and in different positions. And then we also have Sarah Terry here, I believe, this evening. She is my co-chair and served in this space in the year past. So really excited to be joining her. So outside of the Zoom etiquette, I wanted to tell you a little bit about the St. Pete Area League of Women Voters. It's a really important organization. We do a lot in this community outside of reproductive rights, although, this space is really important. we're about defending democracy. We're a grassroots, nonpartisan organization, and it's so critical to have people on the ground in times like these. I think a little bit of apathy is how we got here today, although our panelists will talk about that more. Um, we work really hard to expand voting rights and make sure that everyone's represented in democracy. And so that said, I know this topic, we get questioned a lot on how is this a nonpartisan issue? Because somehow reproductive health got politicized. And the league has taken the position that this is not a political issue. This is a human rights issue. This is a health issue. It's a privacy issue. It's many things outside of a political issue. So for a woman, the league has issued a statement that says the right to choose is a fundamental right that impacts all civic decisions. Without the ability to make reproductive decisions for your own body, women and those who can become pregnant cannot participate equally in our democracy. And the 6-week abortion ban goes against all of the wants and beliefs that Floridians across the political spectrum have. We've made it clear in our polling time and time again that we don't want government intruding in our personal medical decisions. There's no politician that put Amendment 4 on the ballot. The citizens did that. We did that. We collected a boatload of signatures. And the St. Pete League, I'm proud to say, was recognized as the top organization for collecting those positions, not just in our area, not in Tampa Bay, in the entire state of Florida. We collected the most citizen volunteer petitions. And for everyone here that did that work, I want you to give yourself a huge pat on the back. We got this thing on the ballot. It made it through the Supreme Court, and it's going there. So we get to get out there and vote yes on 4 in November. In the meantime, we're going to have these monthly webinars so that you can go and talk to your family and friends about this information, and feel really educated about it, and not like you're, walking through a fire or a really scary place, because this topic shouldn't be scary. It's healthcare. All right. So that said, if you want to learn more about the initiative in Florida, I'm dropping that link in the chat. That is the Floridians Protecting Freedom campaign, and their website has more information there. You can volunteer and get involved through that. And then I am also dropping in here a link to become a league member if you are not a local to St. Pete, because we opened this up to the public because it is such an important topic. I also put the General League of Women Voters Florida page in there, so you can find your local league. And if you're in another state, there's League of Women Voters all over the nation. It's really excellent. And they're doing things like education and environmental and voter stuff, and anything you're passionate about, there's a space for you. There is an annual membership fee, but there's also a pay-as-you-can option, because we believe the league and democracy functions best when everyone can participate equally. And yeah, I did too long of an intro here, and I do this every time, and then I kick myself. So I'm just going to skip on through, join the league, and I guess I'll introduce you to our panelists now. So I have a couple of really excellent experts here today. I have Professor Virelli, a professor of constitutional and administrative law at Stetson Law, where he's been on the faculty for the past 17 years. And prior to teaching, he was a trial attorney in the Civil Division of the U.S. Department of Justice in Washington, D.C. We also have with us tonight Alyssa Morrison, a reproductive rights staff attorney at Lawyers for Good Government. Prior to joining Lawyers for Good Government, she spent 5 years working in constitutional impact litigation at the federal level with the Constitutional Law Center for Muslims in America. And there she focused on challenging racial and religious discrimination in federal trial and appellate courts across the country. Lawyers for Good Government keeps an excellent tracker of reproductive legislation on their website, which I will also drop in the chat, and is a really good resource if you want to follow what other states are doing and what's happening federally. And I will make one last ask of you guys. I am trying to put on one of these monthly. The next one will be on June 5th. And I do have a registration link that I will put in the chat as well. That link does not have a title as of now, because the speakers are a surprise. But you can go ahead and get registered now if you're excited and ready to hear about more content. and then there'll be more information on that coming soon. And if you know anyone who has expertise in this area and you think they would be a good panelist on future panels, please send them my way. You can email the League of Women Voters office at lwvspa.org, and they'll forward that on to me and make sure that we get them lined up and ready to speak. I'd really like to get some people with pre-Roe stories if anybody has a pre-Roe story to tell. And I would also really like to get some healthcare professionals who can talk about the impact this legislation and just judicial decisions have had on the healthcare industry as a whole. All right, so that's it. I am zipping my lips, I promise. And I will hand it over to our legal experts here this evening.
Yeah, and do we have a preference of who goes first, Lindsay, with federal or state?
I think you should go first, Alyssa, if you're comfortable with it.
Sure, let's do it. Okay, so hi everybody, and thank you so much, Lindsay, for that wonderful introduction. As she mentioned, I'm the reproductive staff attorney with Lawyers for Good Government. So we do a lot of work on obviously repro rights advocacy and education, as well as working with providers and other advocate groups and coalitions to get the information and research that they need out there. Especially as laws are changing as rapidly and confusingly as they constantly are. But today I'm going to talk a little bit about kind of the federal landscape and where we're at there, and then toss it over to Professor Virelli to talk about Florida specifically. So as you all know, we're going to do a little quick level setting before I kind of jump into the nitty gritty, and I'm going to talk fast because it's a lot to cover. But so, back in 2022, the Dobbs decision overturned Roe. This purported to send the issue of abortion back to the states, which it certainly did do that, but it did not only do that. And in the immediate wake of the Dobbs decision, we saw all kinds of abortion bans pop up all over the country. At this point, 14 states have total abortion bans implemented, and about half of the states have severely restricted abortion access. And with the implementation of the 6-week ban in Florida, you guys now fall into that category as well. And I'm based in Texas, so I feel your pain there. So yeah, as you know, there are also a lot of states, again, including yours, that are trying to find ways to push back against these restrictions, against these bans, ranging from litigation efforts, advocacy efforts, attempts to legislatively ease the harms of bans with mitigated success, depending on the state, shield laws, and of course, as highly relevant to Floridians, ballot initiatives. And there's also a lot going on at the federal level. And this all has the potential to seriously impact care as things are simultaneously happening in states that are limiting and expanding care at the same time. So that is what I want to talk about today. So the first case, there are two major Supreme Court cases that I want to highlight, and you've probably heard a little bit about both of them. You've maybe heard a lot about both of them, but we're going to walk through it anyway because it bears repeating. So the first one is the Alliance for Hippocratic Medicine versus FDA case. If you've heard about one of these cases, it's probably this one because this one's been all over the news. And I know you guys are a pretty engaged group. And so this is the case where the group of plaintiffs, and we'll talk about them in just a second here, are trying to overturn the FDA approval of mifepristone, which has been in place for over 20 years. So this case is really important, both because of how the litigation has played out, but also outside of the litigation itself, because it tells us a lot about how opponents of reproductive rights are operating and organizing, and also about kind of what they're willing to sacrifice on the altar of restricting abortion, because there is a lot more at stake in these cases than just the issues presented as they relate to abortion. So turning to the specifics of the Alliance for Hippocratic Medicine case, so who are the parties? The plaintiffs in this case, and it's really important because one of the major issues in this case is around whether these plaintiffs even have the right to bring the lawsuit, whether they have standing, right? So these plaintiffs, there's 8 of them. It's made up of a combination of individual doctors who openly oppose abortion and organizations that also openly oppose abortion, specifically the Alliance for Hippocratic Medicine, which comprises 5 different anti-abortion groups and was incorporated in Amarillo in 2022, right before filing this lawsuit, despite none of its members actually residing in Amarillo. The American Association of Pro-Life Obstetricians and Gynecologists, the American College of Pediatricians, not to be confused with the similarly named but non-political American Academy of Pediatrics, and the Christian Medical and Dental Associations, as well as 4 individual providers. And they're suing the FDA. And as I'm sure you heard, they made that all the way from the Northern District of Texas up to the Supreme Court in March, when the court heard oral arguments in this case. And despite the fact that the Supreme Court purported to, wash its hands of the abortion issue with Dobbs, here we are back in front of the court with one case being heard in March and then another one being heard in April. So how did we end up here? Because this case really, if you've read anything about it, you've probably gathered for yourself that it really should have never gone anywhere. I would say in front of a neutral court based on, the well-settled law that kind of undergirds this case, it should have been thrown out at the trial court level. So how did it get to the Supreme Court? And, the first part of that answer is, or the first answer to that question is where the plaintiffs filed it. And again, this tells us some really important things about kind of the strategy and the way that anti-reproductive rights groups are operating. So the plaintiffs filed suit again in 2022 in the Northern District of Texas, Amarillo Division. And that's really important because there is only one federal judge who resides over the Amarillo Division, and that is Judge Matthew Kaczmarek, and he is an openly anti-abortion judge who in the past has a long storied history of all kinds of anti-everything positions. And so this was a pretty purposeful choice of where to file, because again, none of their plaintiff members actually reside in Amarillo. And Judge Kaczmarek effectively, kind of rubber stamped their arguments, and it went through a long, extraordinarily boring and fraught procedural path to eventually making it to the Supreme Court. And once it gets there, at that point, the plaintiff's original claim, which they had originally tried to overturn the 2000 approval of mifepristone, as well as later 2016 and 2021 changes to its regulations for use that made it more accessible. By the time it made it to the Supreme Court, that 2000 approval had been taken off the table. So we're now just arguing, for statute of limitations reasons, we're now arguing about these regulations. So what are these? So in 2016 and 2021, the FDA, after all of these years of mifepristone being safely prescribed for medication abortions, they had, gathered sufficient data to change the regulations for use to make it more accessible. Specifically, what they did is they increased the gestational age limit for mifepristone's use from 7 weeks to 10 weeks, reduced the required number of in-person clinical visits, allowed certain non-physician healthcare providers to prescribe and dispense the drug, and then lowered the dosage. And then in 2020, as well as modifying adverse event reporting requirements to the FDA. And then in 2021, in light of the COVID-19 pandemic and the risks associated with in-person healthcare and in-person dispensing, the FDA announced that it would not enforce the requirement for in-person dispensing during the pandemic. And later they made that change permanent, again, based on, at that point, over 2 decades of solid evidence that it was perfectly safe to do so. And so these plaintiffs, their argument at bottom is that mifepristone's safety record is not what it appears, and that it is actually a very dangerous drug, and that the FDA overstepped their authority in approving it and then in subsequently changing these regs. And so what they're seeking to do at this point, now that the 2000 approval has been taken off the table, is to roll back those regulations that made it more accessible. And that would have been important at any time. That would have been really important and really detrimental to access pre-Dobbs. But now post-Dobbs, that would be devastating, particularly the requirements or the relaxation of the requirements about in-person dispensing, because for many people, folks in expand states, telehealth is a far more accessible option, as well as for people in states where abortion is legal or legal up to a certain point, but it may be difficult for them to travel somewhere. We know that post-Dobbs, maternity care deserts are increasing, providers are leaving states, just the healthcare field surrounding OBGYN and maternity healthcare in general is shrinking and it's moving, right? And so it is harder and harder to access in-person care, and accessing in-person care also has a lot of other complications that go along with that. You know, you have to, presuming again that you're not in a city or adjacent to a city where you can easily access care, you're going to have to plan for travel, you're going to have to pay for it, you're going to have to take time off work, you're going to have to potentially, you know, take care of childcare for your other children, all of these different things that go into it. So taking telehealth off the table is huge. It's also entirely contrary to science, which tells us, you know, the scientific consensus tells us very, very clearly that it is both safe and highly effective for folks to administer medication abortion via telehealth. And another really important thing that the plaintiffs want to do in this case, and we're going to talk about this in a little bit more detail in a second, is they're challenging the FDA's actions under Comstock. And the Comstock Act, again, y'all have probably heard some of this. It's particularly outrageous, so it's definitely broken through to the news. Comstock is an 1873 law that had long been considered dead and has not been enforced in decades and decades, that originally made it unlawful to mail obscene items, and at the time it included things related to birth control and all of that. It was later amended, but it still includes paraphernalia related to abortion. And again, it's not been enforced in decades. Biden's DOJ has expressly disclaimed enforcing it for cases of lawful abortion, but the plaintiffs want to revive Comstock. So yeah, we heard these arguments in March. And again, I know I've talked really fast about a whole lot of stuff, but we could do 5 hours on this case alone. So we heard oral arguments in March, and the court was actually, in my opinion, surprisingly skeptical of the plaintiff's argument on the question of standing. They really didn't get much to the actual merits of the case, meaning the question of whether or not the FDA overstepped its authority. What they were really stuck on, and rightfully so, was whether these plaintiffs actually have the ability to bring the case, because none of these plaintiffs, none of them perform abortions, prescribe abortion medications. Obviously, all of the organizational plaintiffs are not involved in performing or facilitating abortions in any way. So the question of how these providers have actually been harmed is really at the forefront. And in order to bring a lawsuit, you have to show that you have been harmed. And so it seemed likely to me, and again, with all of the caveats in the world, that the court is highly skeptical of their standing argument and is very possibly going to throw it out on those grounds. And that matters, because it obviously would be a win for them to throw it out, but it would not be, it would leave the door open for later challenges. And it would kind of allow the court to sidestep the merits question of whether or not the FDA properly approved these drugs, and sidestep sort of the broader question there of when the court can step in to substitute its own judgment for an executive agency's, like the FDA's, expert judgment. So kind of how this case comes out is also really important, what grounds it comes out on. And we're likely to hear that later this summer. And we have a lot to cover still. So, okay, I'm going to move on to the next case. The next one is the EMTALA case. Again, you guys may have heard of this one, but it's more likely, again, if you'd heard of one of them, it would be the mifepristone case. But so this case is a case brought actually by the administration against Idaho. And oral arguments happened on April 24th. So it's a consolidated case, Idaho v. US and Moyle v. United States, and it flew a little bit more under the radar because it is definitely more technical, but it's of equal importance, in my opinion, if not more so. So at issue in this case is the Emergency Medical Treatment and Active Labor Act, or EMTALA, which was enacted in 1986 to prevent the practice of patient dumping, which is basically when patients would present at an emergency room and they were uninsured or unable to pay for whatever reason. And rather than receiving stabilizing care, the hospital would ship them off to a state hospital. And this led to a whole bunch of devastating health outcomes for patients whose care was delayed unduly for no reason except that they couldn't pay. So EMTALA steps in and functionally protects the right of every person, regardless of their ability to pay or any other status, to access stabilizing healthcare in an emergency situation. So that means you show up at the emergency room, you are having some kind of a healthcare crisis. It does not matter if you can pay or not. The hospital, if they receive Medicare funding, is federally obligated to stabilize you and provide that treatment. And sorry, let me back up. So EMTALA requires that care not just when a person's life is at risk, but also when a person's health is at risk. And they define that very specifically in the statute. But the important part for our purposes here is that Idaho's abortion ban only permits abortion in the cases where the pregnant person's life is at risk. It does not have an exception to preserve health. And this is more severe than most states' abortion bans, including other states who have total abortion bans. And so the question in this case is whether EMTALA, that federal statute, preempts Idaho's abortion ban in cases of medical emergencies, allowing providers to perform abortions in order to preserve the health of their patients. And I want to pause here for just a second to kind of zoom out and reflect on this for a couple of reasons. And the first one is, there's a lot of talk with going back to the mifepristone case that we just talked about, kind of in anti-abortion groups about the idea of like forcing providers who are morally opposed to abortion, forcing them to provide that care. And I really want to kind of point out in this EMTALA case, like this case is not about forcing emergency room providers to provide abortions that they object to. It's actually the opposite. It's about allowing providers to do their job and provide abortions when that is the medically indicated treatment to stabilize someone, and allowing them to do their job without the fear of prosecution that the Idaho abortion ban has hanging over their head, right? And the other thing I want to really zoom out and kind of think about is to really consider how narrow the relief asked for in this case is. So the administration, it's not trying to overturn Idaho's abortion ban. It's not trying to interfere with Idaho's ability to enforce its ban. It's literally just asking the state to allow providers to perform emergency stabilizing abortions in cases where a patient's health is severely at risk. That's it. And that is what Idaho is fighting back against. And I think that's kind of for our overarching conversation that we're having a really, really critical point to remember, because it tells us a lot about kind of how far these laws go and how far the folks who are defending them are willing to push it, because this is really, it's a narrow concession that the administration's asking for. So this case matters. It matters for a lot of reasons. Obviously, it matters for access to abortion in the most like critical, urgent crisis situations, and that is hugely important. We've seen the devastating effects of these abortion bans play out in states across the country post-Dobbs. And I can tell you, I spend a great deal of my time, and Khadijah, my colleague who's on this call as well, the two of us spend a great deal of time on calls with providers, with OBGYNs from across the country. And, for every story of, care that, or a failure of care, I should say, that kind of breaks through to the mainstream media. So, for every Kate Cox, Amanda Zarowski, these kinds of plaintiffs, there are a million stories that are just happening behind the scenes all the time that providers are handling in their day-to-day practice. And so it really is, it's a crisis. And this EMTALA case, it threatens to impact that care. It also threatens to impact just emergency healthcare generally, right? Because if the court sides with Idaho on this one, then it throws into question whether or not a state can just ignore federal protections for care in cases where it has its own law and place that law over the federal protections. And yeah, right now that might be aimed at abortion, but who's to say that it stops there? And it's also really important, again, kind of getting into like the legal nitty-gritty, it's really important on that question of preemption. And that's what I just mentioned, the idea that we can rely on federal protections in cases where states enact harmful laws. If the Supreme Court is to side with Idaho here in a case where the state law in question pretty blatantly conflicts with the federal law, that entirely upends that. And that really threatens a lot of things that we know about kind of our regulatory regime that we rely on. And another important point about this case before I kind of move on. So during arguments, again, it was really interesting. You kind of never know what you're going to get, even when you go into it thinking that you do. We heard a lot of pushback from the female justices, including Justice Barrett, about what scenarios would allow an Idaho provider to step in and provide care. And you had some of those justices reading off real life cases that have happened and then asking the attorney for Idaho, would care be permissible in these cases? And you heard a great deal of pushback from the female justices as the attorney for Idaho kind of hedged on that, right? But then on the other hand, you had some of the other justices pushing back, and Justice Alito, about, I'd say 3/4 of the way through the argument, specifically brought up the question of whether EMTALA's obligations to stabilize a patient apply equally to the fetus as they do to the pregnant patient. So bringing up the idea of fetal personhood and kind of bringing that into the room for the court to consider and potentially opine on in their ultimate ruling. And again, that would have devastating consequences for access, and it would also have devastating consequences for practitioners who are already trying to balance their federal obligations against their state obligations, against their training and how they know how to care for patients, to then add in another element of fetal personhood that actually clinically makes no sense whatsoever. So these are really important federal cases, and there's a whole lot to them that we don't have a chance to talk about today, but they're really critical, and they'll really determine in large part what the landscape for reproductive health care, at least on the federal level, will look like in the coming years. But it's not kind of the only federal thing going on. There's also, all kinds of potential in the coming years for abortion restrictions to happen at the federal level outside of the courts, and really outside of even congressional approval, right? And so one of those things is going back to the Comstock Act that we talked about a second ago, as that's raised in the mifepristone case. And as I mentioned, Comstock is an 1873, it's an anti-vice law. So it's one of these like old laws aimed at just stopping people from doing things that the original proponents of it had an issue with. On moral grounds. So it's this 1873 anti-vice law. I highly recommend you look up Anthony Comstock. He's a character. And it banned the mailing and receiving of obscene matter, as well as articles used to produce abortions. And depending on the administration, like I said, Comstock has not been enforced for decades. But if you have an administration hostile to abortion, they could direct the DOJ to enforce Comstock fairly easily without the need for congressional approval. And if you take a literal interpretation of that law, it could really have the far-reaching impact of functionally banning abortion entirely, because it doesn't just speak to abortion medication, it also speaks to paraphernalia related to abortion. And so if you ban the mailing of that, even in states where abortion is legal, obviously it relies upon the ability to send and receive the supplies that you need for that healthcare. And so that's really important to note, because there's a lot of talk about a federal abortion ban, and that's really important, and obviously would be devastating. But I just think it's important to also highlight that it doesn't necessarily take an explicit ban to functionally ban abortion. And then the same can be said for kind of instructing the FDA to wield its power to restrict access to medication abortion, as well as other medications. So there's a great deal that can be done depending on, kind of an administration's views on reproductive health care. There's a great deal that can be done outside of the courts, and again, outside of Congress, a need for congressional approval. So I will stop talking in just a second here, but, to kind of wrap up before I throw it over to Professor Virelli, what do we do with all this? Like, there's very little that any of us, sitting here watching the Supreme Court hear these oral arguments, there's not much we can do to directly impact the court. And that can certainly leave you feeling kind of hopeless. I mean, or helpless anyway. It certainly does for me sometimes. So what do we do with all this? I mean, obviously the number one thing that I'm going to say is vote. The fact that these things are playing out at federal and state levels tells us that it's more important now than ever to vote in every election, up and down ballot, and to also be really clear about holding candidates accountable for protecting healthcare and setting clear expectations for what we expect of our leadership, as well as educating folks around you, educating and advocating, talking with people in your own lives about these issues. It matters, it really does. Making sure people kind of understand what's at stake and are able to talk about it in a way that cuts through the noise. I know that's incredibly important in Florida right now as you guys push for your own ballot initiative. But yeah, so there are things that we can all do. We can organize, we can educate ourselves and educate others, we can vote. Yeah, and we can just keep using our voices to elevate these issues and, and to tell the truth of the story. And with that, I will stop talking and toss it over to Professor Virelli.
Thank you, Alyssa, and I strongly encourage you not to stop talking. So if there's anything that I say that you want to add to, please do that, because I just learned a lot. I was going to take a moment to say 3 things in connection to what you said. So hello, everyone. Thank you for having me. I've long been an admirer of League of Women Voters. You all were the lead plaintiffs in a case challenging Governor DeSantis's ability to flip Florida Supreme Court justices at the 11th hour. And I spent a lot of time talking to the press about that and quoting you all in defense of the justices who were losing their jobs at the last minute in a way that I thought was unconstitutional under the Florida Constitution. So I'm grateful to be here and be part of this program. The 3 things that I thought everything Alyssa said was interesting, as I know we all did, but there were 3 things that sort of I wanted to comment on. One is agree 100% on the standing issue in the Mephistoprone case. Justice Barrett seemed inclined also. It's not unusual for standing to be sort of an out for the justices when they have a case that is challenging for them, regardless of how one feels about the current credibility of this court. And we'll talk about that in my next 2 comments. And I should say, I spend most of my time doing federal constitutional law. I am not a reproductive rights expert in the way that Alyssa is by any stretch of the imagination, or Lindsay is for that matter. But I spend a lot of time thinking about the U.S. Supreme Court and writing about it and thinking about the federal judicial system and the Constitution. So the standing issue, I think, is a very good point. And I think that's going to be how that case unfurls itself, which is poetic justice in light of the fact that it was filed in a district with only 1 judge, which is something that a colleague of mine in Texas named Steve Vladeck has been fighting against for a long time, and is a twist to the judicial system in Texas that shouldn't be allowed. You shouldn't have 1 judge in 1 district. It allows for judge shopping, which is so the worst of all worlds, and we've seen it over and over and over again with Judge Kaczmarek. So I think the standing issue is a really important one. There were lots of folks in the chat talking about Idaho's standard of care and how it doesn't protect the health of a pregnant woman. And you commented about Justice Alito making the personhood comment, or like the personhood implication in the oral argument in the EMTALA case. Something that I've been telling folks about Dobbs, and I can't stop saying this now that I've been teaching it and thinking about it for a long time, or as long as it's been out. Justice Alito wrote the majority opinion in Dobbs, and it had been 50 years of unquestioned constitutional law that even in cases where abortion had been otherwise prohibited after viability, which of course was allowed after Roe, states were allowed to say that after viability, you can't have an abortion in our state because we just choose not to. And that's what Justice Blackmun did in Roe, and that was 50 years of law. There was always an exception for maternal health and life. In other words, if the life or health of a woman were imperiled by their pregnancy, they could still terminate that pregnancy after viability. Justice Alito doesn't say anything about that standard in Dobbs at all. It is not because he forgot about it. It's not because he's not aware of it. It's because he didn't think it was worth it. Now, at the risk of editorializing, right? What I intend to editorialize about here is the law. And the reason I think that's important is because the only value I can add, and you can decide if it's worth anything at all, but the only value I can add is framing some of these constitutional doctrines to give you all perspective that you can then share with other people so that some of the judicial tropes at play here don't work. It doesn't mean people have to agree with me in terms of the outcome at all. But the thing, I feel confident saying that my experience at least lies in commenting on the quality of the court's reasoning and the integrity of its decisions. And that's something that I've protected my entire career. I have been a defender of the court since I started law school in the late 90s. And I am, but it is also my job to be critical when I think it merits it. And that's what I think I'm doing here. So Justice Alito leaves out life and health in Dobbs, and you're seeing that sort of permutate forward in Alabama, in EMTALA, and it's a really dangerous line of reasoning. I don't think that the majority of the court will go for it, but fetal personhood, of course, is the end of all of this, right? It makes the rights argument almost impossible to defend pregnant women, and is a real travesty. It's the kind of thing that the 14th Amendment doesn't tolerate in its text. It hasn't in its history. It hasn't for 50 years, but there is a segment of the judiciary currently that is least interested in talking about it. And that's something that I think it's important that people understand is an incredible shift, right? So what I talk to my students about, and you all are far more sophisticated than them in terms of your following of this issue, so I don't mean to equate you with them, but what I talk about all the time is shifts in the court's reasoning. And to the extent that Justice Alito is no longer interested in talking about life and health exceptions, that is beyond a critique of Roe, right? That is constitutionally permitted martyrdom. I don't think that's dramatic, right? That's literal. I think there are other parts of the Constitution that would protect against that. I think the Fifth Amendment due process clause would protect against an argument in favor of an argument of a woman who said, I'm going to be killed by my pregnancy. But of course, by the time that plays out, we have the timeline problem in pregnancy cases, which is putting it lightly. So that's a big feature of the current court's jurisprudence, and we've seen it in other state courts. The third one is the sort of argument you see all the time about judges saying, well, now it's up to the legislature, right? It's up to the legislature to do these things. It's no longer a judicial issue. It's up to the states. It's up to Congress. There's some irony in these cases, right? And the irony is that in the mephistoprone case, Congress creates the FDA, and Congress controls every aspect of the FDA. This is the admin professor in me talking, and I promise to put him away immediately because people generally are not interested by him, even less so than the con law version. But the Congress controls the FDA to the letter. If Congress doesn't permit it, it can stop the FDA from doing anything it wants anytime. This court has taken the position both that Congress is not the final arbiter of the FDA's decisions. The court is considering being. And at the same time, we should leave it to Congress and the legislature to figure out the protections for women in the reproductive rights area, right? So there's an inherent tension. Again, people are obviously free to feel about it whatever the way they'd like, but that tension is real and it is not an accident, right? The justices are far too sophisticated to not understand the consequences at that level. They're very simple for people who do this for a living. Those are three things that I thought I wanted to just pile on, forgive me. But my job is primarily to do the state side. I am not a Florida constitutional law expert, but I've been talking about this issue in the press and with students for a very long time. So I thought I would just lay out sort of basically from 1980 until now in very brief terms to give you a sense of what I think happened on April 1st in the Supreme Court's most recent decision, and some of the challenges in that decision, again, to empower your perspective to then do with that information what you will in the public, which is where this organization is most powerful. So, of course, in 1980, 7 years after Roe, the Florida voters enact a privacy clause through the constitutional referendum process into its constitution, protecting the right to be left alone, basically, in the Florida Constitution. That is 7 years after Roe, and I was there in 1980. I was not politically active, right? I was 7. But I am confident saying, and so was the dissent in the April 1st decision by the Florida Supreme Court, that the right to privacy in 1980 meant, in almost everybody's minds, at least in part, the right to access an abortion, because the abortion debate had been a debate about whether there was a right of privacy in the Constitution or not. There's reasons that might be a red herring. That's a different conversation. But that's what happened in 1980. A privacy amendment was adopted by the Florida voters. In 1989, the Florida Supreme Court, 9 years after, before the U.S. Supreme Court decided a case called Casey, which sort of limited some of Roe's protections. But in 1989, the Florida Supreme Court said, yeah, the right to privacy in the Florida Constitution not only protects the right to an abortion, of course it does. It clearly does. And it does so to the point where parental consent and notification are not required of pregnant minors in Florida, because pregnant minors have all the rights of pregnant adults, and therefore they have a constitutional right to terminate their pregnancy without telling anybody. Now, why? Are they prohibited from telling anybody? Of course not. But are there situations where young women may be inclined not to tell their parents or others that they are pregnant and seeking to terminate that pregnancy? Of course there are, and Justice Ginsburg does an impassioned explanation to the majority of why that's true in Casey 3 years later. But the Florida Supreme Court is very clear. The Florida Constitution, which doesn't depend on the U.S. Constitution at all, it is day one of constitutional law that says state constitutions can provide more protections for people than the federal, not less, because the federal is a floor. The federal Constitution is a floor, but it is not a ceiling. States can go beyond individual rights protections if they so choose. The Florida Supreme Court, who ostensibly was around when the provision was enacted in 1980, said unequivocally, this protects the right to an abortion, and it protects it more stringently than the U.S. Constitution protects after Roe. That's 1989. Florida then has a record. The Florida Supreme Court has a record of protecting abortion rights really stringently, striking down notification laws. In 2004, another ballot initiative comes up, and there's a constitutional initiative in Florida adopted by the voters, much like the one we're going to see in November, that says the legislature is allowed to require notification for minors. Minors can be required under Florida law to notify their parents they're seeking an abortion, but they don't need their consent. They can do it without them. Now, of course, that creates a bit of a challenge for young women. It is not a win for sure, but it is certainly not, it is a far cry from undoing abortion protections, and it is still more protection than federal law, because in 1992, the Supreme Court in Casey said federal constitutional law allows Congress to require parental consent. Justice Ginsburg's writes in a passioned and just sort of biting dissent, but she lost. The U.S. Supreme Court in 1992 said, you are allowed to require parental consent. Florida said, not here, because we're doing more than the federal Constitution, and that was between 1989 and 2012. In 2012, another ballot initiative comes up for a constitutional amendment seeking to define Florida's abortion rights as coextensive and equal with federal constitutional rights. So the voters are asked to vote on an amendment that says you can only have whatever abortion rights the federal Constitution allows here in Florida, no more. Remember, the Florida Supreme Court had said specifically, we have more of them here. And the voters rejected that amendment. Said, no, we do better than the feds, and we're keeping it that way. This is not me. I wasn't here in 2012, but the Florida voters took that position to the tune of 55%. Then comes Dobbs. Dobbs is an interpretation of the 14th Amendment of the United States Constitution. It has absolutely no bearing on what the Florida Constitution means. That's just a matter of law. What it did, however, is it stripped away one layer of protection and left only the Florida state constitution to control or impact the reproductive rights of women in Florida. The Florida Supreme Court is now presented with a new statute enacted by the Florida legislature upon Dobbs, or before Dobbs, but stayed until Dobbs was decided, saying no abortion after 15 weeks. But by the way, if the Florida Supreme Court upholds the 15-week law, no abortions after 6 weeks in Florida, right? So you have this sort of waterfall statute that says, we want 15. If we can 15, we want to try 6 also. And the Florida Supreme Court is staring right at not only 45 years of precedent, but a textual command in its own constitution that says privacy is protected, and an interpretation by the Florida Supreme Court within a decade of that enactment, so very close to the beginning of that sort of new regime under the privacy clause, saying, oh yeah, and that means abortion. Privacy equals abortion in Florida. The Florida Supreme Court met all of those things head on. Those of us who were talking to the press were saying over and over again, the Florida Supreme Court has lots of reasons to not do what the U.S. Supreme Court did in Dobbs. The U.S. Constitution does not say privacy. Now, there's lots of us think there's lots of arguments as to why that's a red herring, but it doesn't say privacy. The Florida Constitution does. It adopted the word privacy 7 years after Roe told us that privacy is the right that helps protect reproductive rights. And the Florida Supreme Court, within 9 years of that, said unquestionably abortion. The modern Florida Supreme Court, and Lindsay will correct me here, I'm pretty sure 5 of the 7 were appointed by Governor DeSantis, not 6. but an overwhelming majority of which was appointed by our current governor, said that's not true anymore. Now, do they have the power to do that? Yes. Under the judicial review standards we've had since the founding of our country, yes. So it is not a matter of the Florida Supreme Court doing something they don't have the power to do. But it is a matter of the Florida Supreme Court offering reasons that at least I and a lot of people in my position who do this for a living think are unpersuasive at best and pretextual at worst. What do I mean by that? Well, many of you might have read the decision. It's long, but it's in very big font, so that helps. The Florida Supreme Court basically took the position that what matters is what's called the original public meaning of the Privacy Clause. What did the people who read it in 1980 think it meant? First of all, we can have the conversation, but we can also sort of take it on faith for now, that historical arguments are always more complicated than they sound, right? Any actual professional historian will tell you, and in fact, the professional historian on all of these abortion cases have all said the court was wrong. U.S. Supreme Court, the Florida Supreme Court, all of the people who do history for a living think the justices have been wrong about the history. It's hard. History is not about truth. It is about the story of people, and people don't act in monolithic, singular ways all the time. It's also not true at all that it matters what the original public meaning of the word privacy meant. That is a version of constitutional interpretation that has become in vogue in light of a particular brand of justice that has appeared both at the U.S. Supreme Court and in the Florida Supreme Court. But it is just one way to read the Constitution, and it has not proven to be a better or easier or more reliable way. And it is certainly not proven to be a way that limits the justices' power or choices at all. Right? The argument from original public meaning is judges will tell you, well, I'm just telling you what it meant at the time to the average reader. So it's not me telling you what this means. It's me just describing an historical truth. Even if, so the first answer is that's not how you need to do it, right? The courts are not constrained by law in how they read these documents, right? Their job is to make explanations, to provide explanations that the people they govern will accept and understand. So there's a bit of a red herring that we even have to do original public meaning, and in fact, we don't. There's a very good argument, and my colleague Jamie Foxx wrote an article published in the Rutgers Law Journal that explains in historical terms, and by the way, he is an historian, in historical terms, why the original public meaning of privacy in 1980 in Florida did include abortion. But even if we think it may not have, the Florida Supreme Court spends the majority of the justices, 6 justices voted to basically eliminate the right to terminate a pregnancy under the Privacy Clause of the Florida Constitution, 6-1. Nowhere in that opinion do the justices reconcile at all the idea that in 1980, the right to privacy in America was borderline synonymous with abortion. The debate over abortion was about the right to privacy and whether such a thing existed. Well, we know it existed in Florida because it was written there. So if we're talking about the text of the amendment, which the justices claim, and if we're talking about original public meaning, which we do not need to be, but they apparently are or claim to be, there's almost nothing done with the idea that in 1980, the right to privacy equaled abortion everywhere. Now, they go to great lengths to say, well, there's nothing in the debates about the amendment about abortion. And my colleague going through the original sources and another colleague of his on the East Coast of Florida both wrote articles saying that's because everybody knew what it meant. I'll remind you that 9 years later, the Florida Supreme Court justices then, who were there when the amendment was debated and adopted, it was only 9 years earlier. None of them took the bench at the age of 8. All of them were aware of the original public meaning, and none of them thought that there was any gap between the word privacy and abortion. But the modern court says, the current Supreme Court says, well, the text just says privacy, it doesn't say abortion. Nobody's talking about abortion in the debates, and we think there's all sorts of informational privacy and other things that people could have cared about. Privacy is not part of the original public meaning. We don't care that the case called In Re TW in 1989 said unequivocally the opposite of what we're saying. We think they were wrong because they didn't do original public meaning. Again, there is nothing in the law that tells justices what theory of reading they have to do. We're overturning TW. There is no longer an abortion in Florida. The dissent, of course, says all the things that I've implied. Of course, in 1980, privacy meant abortion. There's a decision in 1989 that is closer in time to the original public meaning, right? That is often a very good source of evidence. In federal cases, we care very much what justices from the 1820s thought something in 1789 meant. This is even closer. That's why I keep making the point that it's 7 years after Roe, 9 years after the amendment. But the Florida Supreme Court undoes all of this. They undo all of this on a theory that says we care about the original public meaning, and then they make arguments from context and historical debates and foreseen problems with the reasoning in 1989. What are we left with? We're left with no right to terminate a pregnancy in Florida, as far as I can tell. Now, the current statutes include life and health exceptions and rape and incest exceptions. So the court didn't have to tell us whether they still are part of the constitutional protections in Florida or not. They didn't have to answer the question that Justice Alito should have in Dobbs. I dare say I am interested to know what they would say, but I'm also concerned to find out what they would say. But they unequivocally undid the right to terminate a pregnancy under the Florida Constitution, which now means that the 6-week ban, which is effectively altogether, because 6 weeks from one's last menstrual cycle is not enough time to determine if you're pregnant, is the law in Florida. Modern day, very recent. All week I've been getting contacts or messages from fact-checking organizations, PolitiFact and others, about critiques of the current amendment that's coming up in November by opponents of it. The governor is one of them. Recently, a representative of Moms for Liberty issued a statement, and they have a couple of talking points. So, of course, we all know what the amendment says. The amendment says basically a right to abortion up to viability, and after viability, a right to terminate pregnancies to protect maternal life and health. For the record, that is Roe circa 1973. That is not unusual. That is not an expansion of what existed in Florida prior to April 1st. In fact, it's less than existed in Florida prior to April 1st. It is effectively the 2012 amendment I talked about, matching Florida law with federal law. The only difference is federal law has gone away also. So Florida would be returned on the November ballot to a state of abortion rights that matched Roe in 1973, but do not exceed them. The governor and representatives from Moms for Liberty have recently said, under this amendment, abortion is going to be mandated until birth. That's a quote from the governor. Consent is going to be prohibited. Parental consent is going to be banned, not going to be allowed to require parental consent. And tattoo artists are going to be able to self-identify as healthcare professionals and perform abortions. I'm comfortable announcing that all three of those things are wrong, and here's why. One, under no circumstances is an abortion ever mandated under law, right? Not that I'm aware of, right? There might be some, but it's certainly not in this amendment. What the best version of what the governor said was, under certain circumstances, basically maternal life and health being threatened, abortion might be available very late in pregnancy. Well, yes, see Roe. That was the state of American law for 50 years. Right? That is not late-term abortions, right? That is not elective late-term abortions. That is protecting life and health. That is anti-martyrdom. That is in the constitutional amendment in Florida. I can't tell you for certain whether the current Supreme Court will find those protections in an unamended Florida Constitution under its current state. Is parental consent gone? No, right? It is going to be up to the Florida Supreme Court to interpret the language of that amendment once it's enacted. The U.S. Supreme Court found that parental consent was permissible under Roe in Casey in 1992. There is a way to talk about parental consent that would fit within a Roe sort of structure, pre-viability, elective abortions, and health and life protections after. Doesn't mean they would have to, but they certainly could. The amendment doesn't prohibit that. That's nonsense. And it's a bit of a red herring, right? Because Floridians have been living in a no consent world for 50 years. the Florida Supreme Court prior to April 1st had told them parental consent is not required under the Florida Constitution. So the governor is arguing that the sky is falling because of the law of the last month and 7 days, right? To try to protect the last month's worth of Florida constitutional law, not the last 50 years, right? And it's important that Floridians understand that. They might still want parental consent back on the books, but to have an amendment that might allow it is doing nothing more than to say, welcome to the world you've been living in for half a century, and many of you your entire adult lives. And the third one is this tattoo artist nonsense, right? Healthcare provider is the language of the amendment. It is true that the Department of Health licenses lots of people to do things in order to keep us healthy when we interact with them. There is absolutely no reason to believe that the phrase healthcare provider would be interpreted by any reasonable judge to include a tattoo artist in the context of terminating a pregnancy, right? It is not necessary in the law to divorce ourselves from reality, right? It is not true that a tattoo artist is a healthcare provider. I think it's absolutely fair to say a dental hygienist is also not one in this context, right? Nor, frankly, is a dentist. And for the legislature to enact laws that said a healthcare provider has to be somebody trained, whether it be a nurse or a doctor in reproductive care, I think is both reasonable, and that we can disagree about that, right? But also certainly permissible under all versions of this. Why do I know that? Because this amendment is effectively Roe. And there's absolutely no reason to read it differently than the regime we understood for the last 50 years. And attempts to describe it differently are textual and misleading. Why did I go on that rant? And I appreciate your all's patience with me. Because I think, and you can tell me if I'm wrong, because you all are the activists in the room. But when I talk to people, I feel most compelled to leave them with that understanding, because I'm confident that the things that I've said are true in terms of their context and their legal reasoning. And I think they put in perspective this amendment. The last thing I've been telling everybody, and I've kept lots of reporters on the phone wanted to be, because I made them hear this part in case they got confused. What the Supreme Court did on April 1st was clarify the meaning of a constitutional amendment in a way that is highly unusual in Florida. So my wife and I are both attorneys. We regularly have to go back and forth over the kitchen table in the most trite, sort of, stereotypical of terms, trying to figure out what those constitutional amendments on the ballot mean. And we often use the League of Women Voters website, by the way, to help, for what it's worth. That's not happening here. The Florida court told us no in November means no abortion protections at all, maybe not life and health later in pregnancy, excuse me. Yes on the amendment means Roe, pre-viability protections, and then only life and health exceptions afterwards, with a possibility of reasonable regulation, some of which people may not like, right? Some of which I might not like. But it is a familiar regime. Typically, when we're in missions, we don't have the Florida Supreme Court announcing what a no vote means, but they have told us crystal clear. No equals no abortion rights in Florida. Effectively none. 6 weeks, right? Is effectively none. Yes means Roe. And I think that's really critical. The last thing, and I'm sorry, is that people ask me, well, what's going to happen if the amendments pass? Are they going to try to gut it? And I encourage you to stop asking that question. And I mean this in the most friendly amendment way possible, is who cares? Because without the amendment, none of it will matter, right? If there are more limiting things to be done, I'd rather find out from the position of an amendment than not. If I am against access to abortion in Florida, then I will gladly vote no, right? I mean, we have a choice. That is our democratic right to make that choice. But it is unusually clear, and I think that's a message that ought to be shared with voters as an opportunity to not be confused and not wonder. And that binary choice, I think, is really powerful and important. And I will stop there. Thank you all for indulging me.
Thank you both. That was really excellent. And I know we could have talked for many more hours about this entire subject, and there's a lot of case law that we've left out as well, and could continue to hit on for a while. But I want to open the floor up now for questions. Does anyone have a question they'd like to pose? You can go ahead and raise your hand if you know how to raise the hand in here, or just unmute yourself now if you have a question. Go ahead and Any questions? We did get a couple submitted in advance. I don't know that they're really legal expert questions, but they're good questions. So I'm going to address them quickly because I think I can answer them. Well, and I think I can answer them all the same way, I think. So I've got 3 questions here. What can we do to ensure that everyone has access to mifepristone? There's a few things you can do with that one. And I think 1, vote yes on 4. We have to, continue to allow access in the state of Florida, at least while we have the chance to do so. 2, get involved in things like the league and continue spreading this information. I think there's a lot of misinformation out there. And like I said earlier, that this is an issue that crosses party lines. This is healthcare, and we've seen it as healthcare for so many years. This is impacting families' lives. We've got the Flirting Protecting Freedom out there who are doing a lot of good work, taking volunteers, and they actually have several jobs posted right now. So if anyone is looking for some part-time work, that's a way you can get directly involved. And you've probably seen the Plan C pills going out for free. That organization needs people to pass those out, put together care packets where they're being left in, domestic violence centers and women's bathrooms, all sorts of really good places. So there's all sorts of places we can tell you to go and volunteer. And the League of Women Voters, while we are nonpartisan, because we're part of this issue, we can work with all sorts of partner organizations who are already doing this groundwork and who we can quickly say, file you into this. Here's this organization already doing this work. So we can put you out there, and also get your friends and family to vote. Make sure everyone's registered to vote. Please. That I know that seems a far step from mifepristone, but it's there. It's in putting the right people in Congress, having legislature who listens to what their populace, what their citizens is making very clear they want is important. I think citizen-led initiatives are awesome. I think this is really cool that we were able to do this as citizens, but I don't think we should have had to. That's a whole nother story. We've got a couple other questions here. How can we ensure that women experiencing complications get instantaneous medical attention that is not hampered by anti-abortion supporters? I think my last answers really answer that in the same way, honestly. And then we've got another one that says, what can we do to ensure that doctors are protected when they suggest abortions for serious health issues? I think Alyssa covering EMTALA did a pretty good job of answering that already. But there are real fears on the horizon, and we'll continue pushing back. And there's legal organizations who are going to continue fighting these things under the law. I think Professor Virelli said this to us when we were getting ready for this presentation. This isn't just law that makes you feel bad. It's bad law in the sense that they aren't following the rules of the system that was put in place. And in the instance of justices, sometimes not, I would argue, upholding their oath. So there's other things that could be done there, but I would be here all night if I got into judicial reform. So I think we have Jennifer Adams with a question here. Jennifer, do you want to unmute and go ahead?
Yeah, thank you. And I really appreciate you all putting this together. It's very informative and a lot of great points had. I put in the comments something about the Florida Supreme Court judicial retentions, and I'm wondering what the thoughts are. A lot of times people either don't vote for that. The ability to put out information about judges is not very great, right? And so I'm curious what the thoughts are on judicial retention in the Florida Supreme Court. And then on the Comstock Act, I'm curious, are there any thoughts about like putting in a postmaster general that would not act in that way, like the Comstock Act, as a way to help prevent if that was to actually go into effect at some point? Thank you.
Good question. Who wants to take it?
So I will throw the Florida question to one of you two.
I can say something about judicial retention. I have spent a long time generally trying to talk people out of voting no on judges unless they had a really good reason. I'm getting closer and closer in my professional life to thinking there might be reasons. We don't get to do that at the federal level. That's Article 3 has solved that problem for us, life, tenure, and salary. But I think at a minimum, it's an expressive value of explaining to an otherwise unaccountable court. And that's generally how we design them on purpose, right? Judges are supposed to be unaccountable because they're supposed to be independent of politics. I think sending a message that justices who were willing to undo not only 50 years of precedent, but a textual grant of a privacy right from 1980 in the service of limiting rights this dramatically is something people could consider. I'm not optimistic that it would work in terms of carrying the vote, because we have lots of data that says those votes are often reflexive yeses from people who vote. But I do think it's an interesting sort of way to get a message across. Not, of course, as powerful as voting on the amendment. As for the Postmaster General, and Alyssa, I'll defer to you on the federal stuff generally, but the Postmaster General is going to be appointed by a president. They have some independence and tenure protections, but I think the more direct Comstock solution, if you have a president who wants to protect it, is just not enforce it.
That's right.
It could be that you would gain the benefit of having a Postmaster General that hung over for a term beyond their own, such that you could have a Democratic appointed postmaster for Republican administration, et cetera, et cetera. But I think the timing of that is so baked in that it would create you'd have to have a really interesting confluence of circumstances to make it a serious benefit or a serious influence on policy, especially because the Attorney General is going to be primarily in charge of enforcing the Comstock Act anyway.
Yeah. Yeah, no, I would second all of that. And I would also add, in terms of kind of eliminating the threat of Comstock, repealing Comstock would be a great way to do that, but we have to have the congressional power to do so, which brings us right back around to voting for folks who will make those choices.
I know we sound so annoying when this League of Women Voters are like, vote, 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 but it's really important, guys. Look where we are. We got a couple of questions in the chat. If the amendment does not pass in November, what will happen to IVF a la Alabama?
Yeah, I can take that one. Yeah, no, that's a great question. So, I mean, the short answer is, nothing from the amendment not passing will immediately and directly impact IVF. The longer answer is that the amendment could theoretically protect IVF and protect to some degree anyway against rulings, fetal personhood type rulings, which is really what happened with the Alabama case, right? And again, I can tell you from spending a lot of my time speaking with providers, that those concerns about rulings based on fetal personhood stretching from Alabama to other states are very real, and that a lot of providers who work in those spaces are actively recommending their patients on a daily basis to have their embryos moved to other states. For example, an Iowa provider, is recommending having her patients move her embryos to Minnesota because of concerns that those kinds of rulings will expand. So again, yeah, it really comes down to whether or not the court has the power, has the justification to make a fetal personhood type ruling, which is directly impacted by whether the amendment passes protecting reproductive health.
Louisiana also has a really good example of this this subject, and I just saw a really good article on it recently. I think if you Google Louisiana IVF, it would probably still come up in recent news. But essentially, the legislation that Louisiana has in place about the fetal personhood language that they have in their legislation has people sending their eggs, embryos outside of state, and because of that, the cost of IVF is it's insurmountable. I mean, we're talking $20,000 plus. And for those who don't know, that argument is that even pre-fertilization is as far as the argument has gone, not that what's in law, but there's arguments as far that the egg itself is life. And so even putting them in the petri dish and then combining them as soon as you're disposing of the person that has been created, and I put person in quotes here because I know this is really important to everyone that I'm saying that properly. I mean that as soon as they're disposed of, that would be an argument would be murder. And so that's as far as the IVF sort of legislation is going. And I know we didn't really talk on IVF too much tonight, but if anybody has anyone that would like to talk on IVF in the future, I'd love to go there and talk about what this is doing to family planning as a whole. It's really kind of disgusting stuff, and it doesn't make a whole lot of scientific sense. So we do have a couple more questions here. What happens if the retention yes vote for a justice in Florida is less than 50%?
You want to answer that one, Professor
Sure.
Virelli? Because I don't know the answer.
Well, I think you'd have to appoint a new justice, and the governor would do that. Again, usually we're up around 90. That's sort of standard. But there's no cost in this. Usually the problem is people vote yes because they quite literally don't know anything about this. And 9 times out of 10, that's reflective of a system that's working, right? Justices often don't become famous for heroic acts. Maybe in Brown, but not often, right? I wonder how many people can even name the majority author of Roe. I did it earlier. It's not a quiz, but I mean, you get the point. So it's a long way to get to 49% approval. But if I think it's a simple majoritarian vote, I'd have to check that. We've never been close enough for me to think hard about what that would look like. But it would be removal. It would be non-renewal. You'd have to have somebody reappointed. And the question is, could it be the same person? And I can't say no.
Or somebody even more drastic, maybe. So yeah, and
Right.
then who's appointing is, we all know who was making those appointments. So that's important information. Did I miss anybody's question? If I missed anyone, could you resend in the chat? I think I got to the call. Okay, so
Oh, sorry.
oh, go ahead.
Oh, no, I just wanted to say really quick, and I know we're almost over time, but I just have to say this or it's gonna make my skin itch. In terms of fetal personhood, while we're talking about IVF and all of that, the Alabama ruling was, particularly direct and explicit because it specifically addressed IVF, but there are fetal personhood laws already on the books in states all over the country, showing up in other things like family law codes and that kind of thing. So for example, Kansas just passed one relating to child support, for fetuses and embryos as soon as conception, and eliminating payment for medical costs if the person has an abortion. So laws like that are also really important to pay attention to, because even if they're not as explicit as what happened in Alabama, they are kind of quietly baking the idea of fetal personhood into the legal code of a particular state. So I just wanted to flag that.
Thank you, Alyssa. That is an important comment. So first, I just want to thank you both for being here this evening. I know this is, it's not a fun subject to talk about. We're talking about it so much lately. It's get off of work and then we go back to it. There's no shutting down lately. So thank you. Seriously, it's been incredible. I thank so many of you for staying on with us, joining us this evening. Again, please join your local league. Even if times are tough right now, we have a pay-as-you-can option. We also have, if times are not tough, we have a gold membership for a little bit more. And that money currently, as the league stand, goes to your local league. And your local league I really believe in local politics. I really believe that that's how democracy works from the ground up. And these people are the people doing the hard work. These women and men, and everyone else is in the league is working really hard to compile vote 411 guides. That's probably where you're all going to get your information. It really is the best resource out there, and that's all volunteer and donor based. So if you can't join, or you're not interested in getting involved, there's these meetings that are virtual, and that's one of the benefits of being part of it too. This was open to the public, but we'd love for you guys to join us and be part of it more in any way that you can. And then I wanted to repitch, in case you guys weren't here in the beginning, we really need future panelists. So I want a panelist a month up until November. I don't want us to stop talking about this. I want some pre-row stories. I want healthcare providers. I want people talking about, things that aren't legal all the time, because I think we might, it's many of us as our attorneys, sometimes it gets a little sleepy, and there can be some more entertaining subject matter. So if you've got that and you're ready to bring it to us, please send us an email at the St. Pete League. And then upcoming Super Saturdays. Super Saturdays, we have one coming up on May 18. You can find those on the league page. Amy popped those in the chat. Those are really, really cool events. We get together in person and virtually if you can't be there in person. And they teach you how to talk about abortion stories. So why this matters to you, why reproductive health care matters to you, how to have this conversation more comfortably with friends, family, neighbors, and they help you shape your story. The first one was last month, and I wasn't actually at that one, but I'll be at the next one. And I heard it was excellent, that it really turned into a really empowering, it was a lot of people who've never been involved in voter engagement before. And it turned out to be a really empowering way to talk through why this matters to so many of our constituents. And in a way where not everybody needs to re-traumatize themselves, and not everyone needs to tell their abortion story if they're not ready to. But there's other ways to talk about why it matters. And so those Super Saturday events coming up. We also have Amy Weintraub put in the chat. We have a fundraiser coming up. I think somebody is hosting a fundraiser.
Yep. I am, along with Stephanie Sembler, and it's this Saturday. I'm going to put it in chat again.
That will be excellent. If anybody is available this Saturday, it's a fun time. We talk about these things, but you also just get to chat with people who are like-minded and all there for the cause. And then Amy, I'm missing one event. What am I? Oh, I'm missing the
the SAS training, the Self-Managed Abortion Safe and Supported. That's how to talk about abortion pills and getting the word out that they can be accessed by mail, even though our providers cannot legally prescribe them after 6 weeks. Folks are more and more accessing them online from other states and even international sources. So we'll have a training on that on May 16th.
Yes, and if anyone already in the league is not part of the reproductive rights little branch of it and would like to be, we can add you to our email list. So just shoot us an email or a contact on the League of Women Voters contact page, and we'll get you added to the repro page specifically. We have although at this point, Amy, I think that most of the league is in the repro group as well, which is great. It's excellent. I'm glad that we have so much support from our local leagues. So again, thank you, everyone. And for those who aren't ready to quit fighting like me, there's a lot more upcoming. Keep following our event page. And then, Jackie, sorry, I missed this one. Any attorneys on the line? So the way I got involved in this, outside of caring about this for many, many years, is after graduation from law school, I started volunteering with the Jane Network, and we have the Jane Network founder on here this evening. We provide representation for minors who need an attorney going through the judicial bypass system. And so this is something that I started doing pre-Dobbs, and it's work that it's very eye-opening to the barriers that the legal system creates to accessing abortion care and healthcare. Even pre-Dobbs, these were problems long before that. When a minor goes to seek an abortion, they have to get that consent from the judge. And there's typically, depending on the courthouse, they might get a court-appointed attorney who may or may not be friendly to the cause. They also typically have to get to the courthouse, so they have to get to file. Then their hearing has to be scheduled. So that means they have to, in school hours, get to the courthouse 2 separate times. Sometimes after they're filing, they're waiting there for 4 hours to even get their hearing assigned. And then once they actually get the hearing assigned, it has to be within 72 hours. They have to get back. So twice in 1 week, and now before 6 weeks, they have to get to the courthouse, sit there, hope that the judge and that their court-appointed attorney is friendly. So if any attorneys are on the call and want to volunteer with the Jane Network, we're pairing people up so they can file their notice of appearance with the minors and know that they have somebody who's really fighting for them, and know that they have an appellate team waiting and ready to file an appeal in the case that the judge denies their bypass. So yeah, I want to make sure I plugged all those things. So many things tonight, everyone. I'll stop spieling and go enjoy your evening and let me know if you have any other questions or anyone who is ready to speak at the next one. Thank you all.
Thanks, guys.
Thanks, everyone.
Seemed like it went really well.